Greetings friends, now we will have a look at the third session in the international commercial law. This will be more of academic type. Those who are not that much interested in international commercial law, they can skip this video. Before we begin this topic, I would like to introduce three concepts that are there in international contract law. First, we will discuss these three. The SGA, Sale of Goods Act 1979, ACTA, UCTA, Unfair Contract Terms Act 1977, and ROMALPA. We will understand these three terms in this video. The SGA, or the Sale of Goods Act 1979. The Sale of Goods Act gives a small number of compulsory rules concerned with a bunch of presumptions and implied terms which try to reflect the commercial expectations in the most usually agreed sales contracts. In absence of contrary agreement, these terms will govern a contract within the Act's power. This definition we have taken from lawteacher.net website. And then the second concept for this video is ACTA, the Unfair Contract Terms Act 1977. This is an act of the Parliament of the United Kingdom which regulates contracts by restricting the operations and legality of some contract terms. It extends to nearly all forms of contract, and one of its most important functions is limiting the applicability of disclaimers of liability. This we have taken from legislation.gov.uk. We'll go to that website and try to read a few sections from there. Introductory text. Part 1, Amendment of Law for England and Wales and Northern Ireland. It has the following sections: Introduction, Scope of Part 1, Avoidance of liability for negligence, breach of contract, etc. Section 2, Negligence liability. Section 3, Liability arising in a contract. Section 4, Unreasonable indemnity clauses. Then for liability arising from sale or supply of goods, we have Section 5, Guarantee of consumer goods. Sale and hire purchase, Section 6. Section 7, Miscellaneous contracts under which goods pass. Other provisions about contracts, Section 8, Misrepresentation. Section 9, Effect of breach. Section 10, Evasion by means of secondary contract. Then we have explanatory provisions, Section 11, the reasonableness test. Section 12, dealing as a consumer. 13, varieties of exemption clause. 14, interpretation of Part 1. The Part 2 contains sections 15 to 25. They are about amendment of law for Scotland. Then the Part 3 has provisions applying to whole of United Kingdom, which contains miscellaneous and general sections. Then it has 4 schedules. Schedule 1 for scope of sections 2, 3 and 7. Schedule 2 has guidelines for application of reasonableness test. Schedule 3, amendments of enactments. Schedule 4, repeals. Then we'll go for the third concept of today, ROMALPA. ROMALPA clause is usually included in contracts when the companies sell the product on credit. The buyer does not own the product until it's paid in full. A ROMALPA clause is normally included in contracts that deal with companies selling their products on credit. This clause states that the buyer does not actually own the product. They are purchasing they own the product until they are own the product they are purchasing until it has been paid for in full. This we have taken from upcouncil.com. And then I would like to end with this complimentary quote from Chief Justice of India, or if he has changed, we would call him former Chief Justice of India, Mr. Mr. N.V. Ramana. He says that one must keep the option of knocking on the doors of a court as the last resort. I say this after being in the legal profession for over 40 years in different capacities. So it's good to have an arbitration clause in the contracts. You can make different parts of the world as the seat of arbitration when you are dealing with international business. For example, you can make London as the seat of arbitration, or Dubai, or Singapore. Recently in Telangana, southern part of India, also arbitration center has opened. You can choose any of the arbitration centers and then try to minimize or avoid going to the courts. Okay, thank you. Bye bye.